Good morning, everyone. We meet today to discuss the burden on federal laws and regulations and what it has on state and local governments today. This is a hearing on the Unfunded Mandates Reform Act and some opportunities to be able to do some improvement to support it for state and local governments. Unfunded Mandates Reform Act in 1995 intended to relieve state and local governments of many of the burdens that are coming down from the federal government. We'll also discuss how we can build upon UMRA's, and that's Unfunded Mandates Reform Act. We affectionately call it UMRA around here because it's a government anything. We can also talk about UMRA's successes and the ways that we can address some of those. Unfunded Mandates Reform Act was a result of bipartisan recognition that many decisions made by the federal government have significant costs, particularly to state and local governments. UMRA provided better quality information to Congress and the agencies as we contemplate new requirements that will add cost burdens to local governments. But the benefits of UMRA on state and local governments have fallen short of their intended goals. UMRA is complex, contains many exceptions, and as a result, federal actions that affect state and local governments do not benefit from the consultation and analysis required by UMRA. Government Accountability Office has found that issued regulations seldom trigger UMRA's reporting and consultation requirements. There are many reasons for this. Could be because the rule was promulgated by an independent agency, or the regulation was issued without a notice of proposed rulemaking, or perhaps the requirement in the regulation was considered voluntary as a condition for federal aid, or the regulation did not meet the dollar threshold for UMRA. All of these complications allow a lot of opportunities for a lot of loopholes. Implementation of UMRA could be improved. Various experts also told GAO that the process used to consult with state and local officials needed to be more consistent. Then more could be done to involve state and local governments in the rulemaking process. This goes back to a basic principle that we have, is that individuals who are affected by a rule should actually have a voice when that rule is done. I've heard the same sentiments from several officials in state and local governments. The very public servants that will later implement a regulation are not consulted early enough to improve the regulation or are not given enough time to make the changes required to be in compliance. The provisions of UMRA require us to ask hard questions about the balance between federal government and the governments closer to the people. We cannot pass the burden to them in times of scarce resources without due consideration. During my tenure in the House, we held 3 hearings on the effects of UMRA and potential improvements on the statute. I look forward to hearing more insights today. It's time to revisit UMRA. H.R. 50, the Unfunded Mandates Improvement and Transparency Act, or what's also called UMITA, proposed by Representative Virginia Foxx, who is here as a witness to begin this hearing, and its Senate companion S-189, introduced by Senator Fisher, was conceived to strengthen the original 1995 UMRA legislation. Representative Foxx, I want to acknowledge your leadership on this issue, your tenacity on behalf of state and local governments, and I've been honored to work with you over the years on this important issue. I know this has already passed the House and has been a point of conversation of how do we actually move it through the Senate. UMITA improves on UMRA by reflecting much of what we've already learned since the original UMRA passage. It updates the legislation to reflect current CBO practices, address current exceptions to UMRA analysis and consultation, allows for an analysis of mandates to states and local conditions about their grant aid, and it codifies OMB directives to agencies on how to consult with state and local governments in an effort to enhance consistency of these efforts. H.R. 50, when it passed the House in February 2015, was supported by major stakeholders representing state and local governments. I'm optimistic about its process in the Senate, but I do understand full well the challenges that we face. I look forward to hearing from our panel today about the real cost of federal decisions on state and local governments, how UMRA has worked, and actions that Congress could take to create a more thoughtful decision-making process and that balance between state and local governments. With that, I recognize Senator Heitkamp for her opening remark. Yeah, and it is the grand challenge because when you talk about regulations, immediately there's a whole group, and going back to your statement, Mr. Pierce, it's this one whole group that says, oh my gosh, we need to not do more regulations, not make this more difficult, and another group that says it is already incredibly difficult. We can't fix it unless we streamline it and work our way through the process on it. I am interested, Senator Bramble, your comment earlier about see if I get this term right, a federal stress test in Utah. That you're trying to evaluate the cost, federal dollars that are coming to it, what that actually costs the state, and I'm assuming, is it worth it then based on the mandates or, as Professor Posner had mentioned before, the Trojan horse coming to you of the grant with the requirements in the back of it. Is that what that is? Tell me a little bit more about that.
We have what's called a Federal Funds Commission, and one of the concerns that we have at the state level is you have the state budget that we control, and then you have all of the federal programs that come into the state, and most states, the federal monies dwarf the state budget. Right. And so the challenge for the states, if you look at what's happened during the economic downturn from 2009 forward, what happens when federal funds aren't there? In the West, payment in lieu of taxes is a major issue for our states. That's the equivalent of property taxes. And when a state like mine has roughly 70%, it's actually about 68% of the land mass owned and controlled by the federal government, and PILT, the payment in lieu of taxes, is not in the federal budget. What does that do to the state? And that triggered us to take a look not just at that one issue, but across the board. What would our state budget, what would our financial affairs look like with reduction in federal funding across the board in all of the programs? Right. And the stress
testing
is
still entirely likely. So let me ask this: have you been able to determine, for instance, I'm just going to pick apart education? If most states' education dollars coming to their state, between 8 and 10 to 12% of the dollars for education are federal dollars that are coming in. Have you been able to determine, if we said no to those federal dollars,
yes,
what the cost would be and the difference would be, and how do you actually measure that?
On education in our state, it's a little over 7% of the total education budget comes from the federal government, and we actually have a plan that we could implement if those funds were no longer available. And that the issue is, how would the state continue to maintain government services, maintain its role without the federal funds? And it was more than just an idle curiosity, because of the challenges that the federal government has with debt, deficit, those kinds of things. It seemed to be the responsible thing to do at the state level, to look and say, what would the impact be?
So then the question, have you been able to determine what you spend a year on education just fulfilling federal mandates, and what that lines up with the dollars that are actually coming into the states?
You know, we have, but I don't know what that number is.
Well, that's fine. But the reason I ask is that this has been an interesting conversation among multiple states, trying to determine, as now, as you mentioned before, the Trojan horse coming to you and saying, here's a grant, here's an opportunity for you to be able to partner, we'll give you additional federal dollars if you do this. There are some states that have asked the question, if I'm spending more, I think, fulfilling the federal mandate than the federal dollars actually coming in for this, but most states don't have the resources or the process in place to be able to actually answer that question. They think that's true, but they've never had the opportunity to be able to actually evaluate it. If y'all have developed a method to be able to measure that, that's something multiple other states would be interested in, and it may be something that would be of great benefit to many states, if that makes sense.
That is actually part of the process of what we call our Federal Funds Commission. What is the cost of the unfunded mandates? What is the cost of the federal programs? And Senator Heitkamp, if I could go back to your question about between the state and the locals, I'll put on my hat as a Utah senator rather than president of NCSL to answer that. In our state, we have an administrative rules committee that, when there are, so we pass legislation, and then we authorize the executive branch to promulgate rules to implement. When those rules are being drafted, the Administrative Rules Committee, when they are prospective rules, they go before the Administrative Rules Committee, and we take input from the stakeholders, and that may be the Utah League of Cities and Towns, it may be the Utah Association of Counties, it may be the Association of Special Service Districts, it may be stakeholders across the spectrum, and whether that rule gets implemented, modified, or put on hold is a direct function of that input before it becomes effective. And then, as for rules that are already in place, we guard jealously the legislative prerogative of setting policy, and we expect the executive branch to carry out that policy. We just had an example that demonstrates that. Ultra-low NIOX water heaters. We have a problem with our air quality in Utah because of mountain valleys and inversions. There's broad-based support for a requirement that all water heaters, new water heaters sold in the state, should be these low nitrogen, ultra-low NIOX. Our Department of Environmental Quality issued a rule that required that. It went to the Administrative Rules Committee, and that rule is being repealed in favor of the legislature. There's a bill before the legislature. We adjourn March 10th, but there's a bill that's being heard today, as a matter of fact, dealing with that requirement. And while we repealed the administrative rule because we didn't believe they had the authority, the legislature is now debating what that authority should be, because we guard that at the state level, we guard that jealously, but we do have a process for the local political subdivisions to weigh in both during the promulgating of the rule and after the implementation of the rule.
Yeah, we have the same kind of rules committee in North Dakota. I think can be a fairly common model. I have to issue my apologies. I have to run off and give a floor speech, but this has been very enlightening, and I know we will continue the dialogue, so I'm sorry.
That's great.
Yeah.
I'm going to talk about retrospective review while you're gone then. I'll just stick with some of your favorite subjects. Let me bring that up because this is a big deal for Senator Heidkamp and I both to deal with retrospective review, and is one of the challenges that we seldom get information. Once an estimate is made by CBO and they say this is going to cost $95 million or $150 million to the economy, whatever the number may be, we're now 5 years past, it's fully implemented, it's rolled out. No one ever goes back to ask the question, was that correct? And is that regulation working as effectively as we thought? So one of the areas that I know in Representative Fox's bill deals with this idea of a look back from a committee for a committee chairman or a ranking member to be able to make the request and say, let's go back and revisit that regulation. Did it meet the target costs that we expected, and is it accomplishing what it said it was going to accomplish? The logical question is, if it's not working or if it's costing 10 times as much, maybe there needs to be a change in the statute, or maybe it needs to be revisited in the regulation. Comments on that from anyone on the process, because that is a major part. Mr. Lutz.
Yeah, I don't think you're going to want to do that for everything, but if you said, you know, when state and local government stepped in and said, this is not working for us, your estimates are way off, that could trigger that. I think you'd put an onerous kind of burden if you tried to do it on every piece of regulation that came down the pipe. But yeah, it would give us, at least at the local level, a chance to argue our case and say, hey, this really didn't turn out the way we thought it would. And I think that would be beneficial for us.
Okay. Mr. Pierce.
I certainly agree with you completely that retrospective review is a very important function. And as I'm sure you know, each of the last 3 presidents has issued an executive order that requires every executive branch agency to engage in that process.
But do they?
No, because they don't have the resources, because of rulemaking ossification, because it takes too many resources to perform that function. At the same time, they are unsuccessfully attempting to issue the rules that you say have to be issued, amend the rules that need to be amended. They simply don't have the resources to perform those functions. And the particular mechanism in this piece of legislation raises very serious constitutional questions under a series of Supreme Court opinions in which the court has basically said the task of Congress is to legislate, and when a member or even a committee of Congress gets into the business of directing a federal agency to do something, it at least raises serious questions.
So the basic oversight role of Congress is also there, and that's been supported by multiple Supreme Court cases as well, that any committee could reach in to an agency, and as this committee has done multiple times, and said, here's a list of questions and we need information and facts, and that agency then provides us the facts and the details. This type of retrospective review asks the question, this is the estimate that you made as an agency 5 years ago. Did it prove to be correct? That's an oversight role. If an agency gave an estimate that was far out of bounds, we'd want to know why, and how can we change that process so that we get a more accurate look at it, or to be able to evaluate, you created a regulation in hopes that it would do X, Y, Z. It didn't. It did A, B, C instead. I think that's a fair part of oversight.
I agree with that. I would just go back to, they don't have anything like the resources necessary to, that's a very difficult task.
Yes, sir.
And it takes a lot more than the resources they now have to do it.
All right. Mr. Poster.
This reminds me a little bit of something that Senator Portman, when he was head of OMB, did under the Bush administration called Program Assessment Rating Tool. They tried to review every one of the 1,500 programs in the federal budget, 300 every year. It was far too much. It beat everybody up. Nobody could pay attention to it. I certainly support the retrospective process. I think you might want to organize it more on a priority basis, as was suggested, maybe by a portfolio. So maybe one year you look at all agencies regulating food safety, and you do a regulatory look back on them and a kind of a reassessment of how well all 19 agencies are doing inspecting food, for example. That might be a way to more rationalize that process and avoid some of the problems that was just discussed.
For Senator Heitkamp and I, one of the things that we have proposed is for major rules, as they go out the door, there is a scheduled time for retrospective review and no longer than 10 years. And so that everyone knows when the rule is finalized, we also know exactly what year it will be reviewed, and every 10 years it's reviewed, and it could be 5, it could be 10, it could be 7. The agency sets that time period, but it's a predictable time period to be able to have some review. And so again, they can budget for it, they can schedule it, and they know what is coming. We've talked a lot about the impacts on state and local governments, and for the Unfunded Mandates Reform Act when it was passed, the loopholes that are in it, areas where it did not trigger this type of disclosure, which, as you've all mentioned, is informational, basically, to Congress. So that Congress, when they're making a decision, they can have good information. Those loopholes that are out there, can anyone identify any particular bills or conversations that have happened where one of these unfunded mandates got through and it didn't trigger some of the review? Yes, sir, Senator Brandwell.
Yeah, I've got a couple of them. One of the problems with the UMRA criteria starts out with the basis that if it's already an unfunded mandate, then it's only the incremental change that would be subject to the criteria of fitting whether there's additional review. But two examples. One is the Individuals with Disability Education Act. The federal government didn't maintain the funding commitment to fund 40% average per pupil expenditure. The mandate continued, the funding dried up. It didn't hit UMRA because it was in place already, and the fact that the federal government was no longer funding it, but the requirement was still there, it didn't trigger UMRA, but the state still had to comply with the act. Parts of the Real ID Act, we have the same kind of situation. And I think that gives an example of one of the loopholes where even if it's a mandate that's a funded mandate, when the funding dries up, there's no triggering UMRA in those cases.
Okay. Let me ask the where and who question. Dr. Posner, you had mentioned before about trying to do this intergovernmental process. That begs the question of where does that land best that it's most effective? You had mentioned outside groups that had done that here in this town and tried to raise that information to all bodies. The White House, the Congress, different groups have been out there. Where is the place that it would be most effective to make sure if we're going to have intergovernmental conversations, it actually has impact? Is that in OMB's area? Is that here in Congress? Where is that?
Well, the one that was eliminated in 1995 was an independent commission appointed by the President and approved by the Congress, about 30 cabinet secretaries, state legislators, county board supervisors, mayors, and governors. And I think that had a formative role in certain areas. General revenue sharing's formation, the Reagan federalism program, and several others. You know, I think that may be a good place for it. I guess my point also is that I think they need to be populated in the various policy-making circles. So Congress had a subcommittee on intergovernmental relations in both the House and the Senate that worked with the ACIR on issues. So that's the way things get done. As we know, it's not just one hand clapping. And so I think that's what we're missing, is that population of the intergovernmental perspective and in both the Congress and the executive at the very least.
Okay. Senator Brown.
Mr. Chair, this is a document, Congressional Budget Office cost estimate on H.R. 3821, dated February 11th, 2016. Let me read from it. For large entitlement programs like Medicaid, UMRA defines an increase in the stringency of conditions or a cap on federal funding as an intergovernmental mandate if the affected governments lack authority to offset those costs while continuing to provide required services. And then it goes on to say, because states have flexibility within the Medicaid program to offset their financial and programmatic responsibilities in order to reduce costs, CBO concludes that the new conditions or resulting costs would not constitute an intergovernmental mandate. Medicaid is the second largest expenditure in the state of Utah, second only to education. And most states find that, and yet Medicaid itself doesn't trigger UMRA. And changes to Medicaid don't trigger UMRA. Under the Affordable Care Act, the Medicaid expansion, the 90-10 split, our state is one of 16 or 17 that haven't expanded Medicaid, but that major federal mandate in healthcare doesn't even trigger the UMRA criteria.
Mr. Luce.
And I'll take it a step further, because what happens is at the state level, when they are dealing with the Medicaid issues, in Florida at least, they offset, and the county level picks up a percentage of that. And it's debated all the time in the courts as far as how they get to the percentage, and it has been a battle between the state government and us on an ongoing basis. We ran up a $500 million backlog of disputed bills. You've got people moving in and out of the state, and so, we're not a Medicaid provider yet. The state had figured out that they were going to ask us to shoulder part of it. So I hate to say it, but it flows downhill, and we're kind of where the buck stops in local government. And we want a seat at the table, and I commend you for this. I think this is a great tune-up of the existing legislation, and we would just like the opportunity to be there early and be there throughout the process, and we don't think we'll add any regulatory and additional burden. But I think you're spot on with where you're heading with this.
Okay. Mr. President, can you talk about your Trojan horse conversation earlier about grant conditions and such? And you said some of those are coming much later. You take the grant money, then suddenly you find out after the fact. Here's what that means.
Yeah, I mean, I think some of the Medicaid requirements that are imposed after the fact. There's actually a Pennhurst decision, several of the Pennhurst decisions the court made. One of them that Justice Rehnquist did was about the Vocational Rehabilitation Act, which at the time was $1 billion a year program, and it had some. After the states had gotten used to the program, the federal government imposed additional requirements for due process and the like, and the court ruled that was unconstitutional. It was a retroactive rule that burdened the states and was it was almost like they proposed a doctrine of fair notice of sorts. But they're just, these things are, when you have a major program, highways, education, these kinds of things are part of the cost of doing business in some sense. But it's when you're, for example, doing a highway program and suddenly Congress decides to slap on the 21-year-old drinking age and a 55-mile-an-hour speed limit and drunk driving tolerance levels, so that you wonder whether the purpose of Congress is to fund the substantive activity or to use it as a vehicle for delivery of regulatory mandates. And increasingly, it seems more like the latter. So those are the kinds of things we're talking about where since 1956, we've had a cooperative relationship financially where the federal government collects the gas tax and redistributes it. But with now this overlay of regulatory mandates that have largely maybe overtaken the point of the program.
Okay. Let me read a quote to you. This comes from, and this has been an ongoing long-term conversation about this bill and about any other changes to unfunded mandates reform. When I was serving in the House, Susan Dudley came and testified early on before this piece of legislation was even written. We were talking about just the problems with the Unfunded Mandates Reform Act. In 2011, to one of my questions, she answered this, or she made the statement: to broaden coverage, Congress should consider aligning on the language with that of Executive Order 12866, your comment before, and or extending it to include independent regulatory agencies, which are not currently bound by the executive order either. To make the executive branch more accountable for the goals of UMRA, Congress could provide OMB oversight authority beyond certifying and reporting on agencies' actions. Congress might also want to expand judicial review under UMRA so that, for example, an agency's failure to justify not selecting the most cost-effective or least burdensome alternatives could be grounds for staying or invalidating the rule. Mr. Pierce, you had made a comment about that earlier, that you had some concerns in that area of, again, ossification and making this much more difficult, as you had mentioned before. It is extremely helpful in many areas if you know that there is a way to be able to restrain an agency, to say, if you don't follow the rules, as with the Clean Air Act, Clean Water Act, outside entities can step in and say, no, you've got to actually follow the rule itself and the guidelines. What is the barrier is if when the federal government is promulgating a rule, they don't consult, they don't engage as they're asked to do, is if states and counties can step in and say, at least you have to consult us, slow down the process. That judicial review being the stick, I guess, that the states could use to be able to say, you didn't consult us.
Yeah, let me try that one. Let me start by saying that Susan is a colleague and a good friend, and I agree with her on most everything, including the desirability of trying to make 12866 and whatever you folks do with UMRA fit together nicely.
And that is a lot of the conversation of codifying this. We've done it now for 2 decades. Let's go ahead and make it the standard, because each administration says that is the executive order, but they also know, okay, if we're busy, we're not going to follow it because it's not really statute. We will generally follow it, but at times we won't.
Once you get the courts involved, you are really unleashing something over which neither you nor the executive branch have any control at all, and I have no idea what they would do with that. And in many circumstances, it has unintended adverse effects far worse than the intended beneficial effects. And that comes back to why I'm concerned about efforts to codify provisions of 12866, for instance, where sure, a new president could change it, but we've had a string of presidents of both parties who have said, we like it, and have kept it the way it is, and kept the courts out of it, which to me is one of the strengths. They implement it, and that allows them to sit down and talk with agencies and have a dialogue with federal agencies and tell a federal agency, I want you to go talk to the folks in Utah or the folks wherever. Courts can't do that. Courts are blunderbusses that come in 5 years after the fact and say it was all wrong, start all over. I don't like that.
No, and I would agree, but when you can get some clarification, once the courts have gone through that painful process of multiple years, you get a clarification and everyone agrees on this is really the process, or Congress comes back and says that's not at all what we intended, we're going to fix and provide some clarity to it. The key aspect is, right now with 12866, there may be consultation, but it may not be in a way that people felt like they were consulted. I've had several agencies that a rule would come out, and I would say, did you consult anyone on this? And they would say, yes. And I would say, who? They would say, well, we have a group that we work with and consult. Well, how was the process done? We do consultation. With who? This group that we consult. Who's on the list? Well, we don't really put their names out. Okay, well, the people that were affected by it never felt like they had a voice to really say, so suddenly a guideline or a rule comes out that's fairly significant that changes either their staffing, their budgeting, or materials, and they never got a voice. Someone did, but no one who's the someone. So allowing the agencies to define the someone at times gets a little too loose.
I agree, and I agree with Professor Posner's point very early on in the hearing that you can't really solve that with legislation. It's too complicated, too variable. I've been working on the Clean Power Plan coordination process. There's about 8 agencies in every state that have some role in the process of implementation, assuming that that rule is ultimately upheld and implemented, trying to figure out which agencies, and they differ. They differ in their powers, they differ in their perspectives on what should be done, trying to find them and say, okay, EPA usually works with the natural resource agencies. Well, in the case of this particular rule, the most important agencies are the public utility commissions. Well, 7 of them are elected. The governor has no power over them. The people are the only ones who have power over them. Others report to this. They each have trying to figure out who to consult with in a very complicated 50-state, and within each state, 7, 8 agencies with overlapping or conflicting power. It's a very difficult process. I don't think you're going to be able to solve it with legislation, and I'm not sure how else to solve it. One suggestion is you could bring in, as at least for informal consultation, my former colleague at Columbia, who runs the American Law Institute, that was responsible for getting the Uniform Code. Lance Liebman has been working on this for decades. His experience is it's gotten much, much harder. The things they were able to do in getting states to agree 20, 30 years ago, they can't get that level of agreement. They can't even get states to agree on who within the state is the spokesperson.
So what about something just as basic for major rules like an advance notice of proposed rulemaking? So it's a Federal Register, publicly announced, everyone knows. Now you're not having a matter of chasing down who is the right person within the state. It's a public announcement, but we get in before the rulemaking actually begins. We get greater consultation early on in the process. So before there's text written and everyone's fighting about that word has this thing, it gives the ability for states, counties, affected parties, whether that be independent businesses, whatever it may be, they can actually rush in and say, have you considered the tribal impacts of this? Before you write the rule, think about this.
Advance notices of proposed rulemaking certainly can be beneficial, and agencies sometimes use them with good benefit. They definitely add to the time required to make a decision. They add to the complexity. And also, what you're suggesting assumes that there is not a draft until the agency issued a, that's not true.
Correct.
And because of the way the courts have defined the requirements of a notice of proposed rulemaking, the courts have defined that, not the way Congress defined it 70 years ago. They have redefined it in such a way that as a practical matter, the first notice has to be the final. Because if you make any change, you have to justify it to the satisfaction of the court. So the easy way to minimize the burden and risk of judicial review is by making all of the decisions before you ever put anything in writing. And most agencies, EPA is a good example, they have hundreds of meetings through which they come up with the initial draft. All you'd be doing is backing that process up and saying all those meetings have to take place before the issuance of the advance notice of proposed rulemaking, because the courts would just come in and say, if you've made a change, you have to justify it. The easy way around that is don't make changes, which means as a bottom line, make all your decisions before you ever issue the notice.
Which we're back to the same issue then.
Yes.
You don't get public consultation. The county never gets an opportunity to be able to speak into it because they've got a group of folks that they normally work with and a group of attorneys that hash through the issues, and they say, we think this is the tightest language that we can make it work.
In the informal process, that I think is exactly right, and it's a big problem. In the formal process, they certainly have the right to come in with comments, and there's been a lot of empirical studies that show that they simply don't. They choose, in most cases, for whatever reason, I'm sure a lot of this is resource problems at the state and local level, they choose, they say, oh, somebody just told me some federal agency is proposing to do something we care about, and we have a right to comment on it. We don't have the personnel, we don't have the time, we don't have the resources, and often just trying to figure out, is this the governor or the attorney general? In many cases, they dislike each other intensely and have completely conflicting views. And so if we say something on behalf of the governor, well, the attorney general is just going to come in and say that's all wrong. Can we clear it with, this is a horrendously difficult practical problem that I know you appreciate it. It needs to be solved, and
it's also,
I think we all appreciate it, but I don't have a good solution.
Right. It's also why federalism is so important, that the majority of these rules and issues should be handled on a state level, state to state, rather than a federal. But the things that are federal, that's a whole different issue.
38 types of gasoline in the United States today is a problem.
We can talk about, now that the other, some other folks here that are strong advocates for it are gone, we can also talk about ethanol requirements as well, but that's a whole different issue. Dr. President.
Just a quick footnote on this. I think the Earth and the Moon and the stars on consultation were aligned 6 years ago with the Recovery Act. It was tremendously urgent to get the money out the door, and I think GAO did a lot of studies on this. We have a book where we finished on this. That was kind of a peak where governors, mayors, president, the vice president, the agency heads, all were kind of focused on that one program. And the administration did a remarkable job in working with both the program people across within the agencies, as well as at the top of the vice president and the budget director. They did weekly phone calls with states, state representatives and governors, and I think everybody felt good about what happened. And there was also tremendous visibility to that spending. So that, you had that reinforcement that everybody was kind of under the gun and the glare of publicity and transparency. A lot of information was being flowed, and the system worked. So that was under a lot of stress. I think what we're talking about here is much more complicated when you're talking about rules and the like. But there have been extraordinary periods where this has come together, and it might be worth studying that to see what lessons we can learn.
Yeah, the accountability on the backside of that was also very important. So, Senator Bramble, let me, if there are any final comments, I'll allow you to make them, but the votes have just been called. You know exactly what that means as far as timing. And so we'll wrap up here in just a moment. Senator Bramble.
Thank you. I just want to comment very quickly on the consultation. It's also a matter of timing. Some agencies, in talking with staff at NCSL and colleagues across the country, the timing can be critical. If an agency calls 12 hours before the rule is effective and then claims that, well, we reached out to the state, that really doesn't count. I mean, they may check the box and say, we consulted immediately before it became effective, but that's not the kind of consultation that works.
Right. And that is an issue where that's the reason we have the courts to say, clearly the law wasn't followed as it was intended to be followed, and now what happens? And I get the dynamic of it, but with no stick in the process and no voice that comes back, you struggle with how do you actually maintain enforcement consistency on this. Before we adjourn, I would like to announce to folks that on March the 17th, the subcommittee will hold a hearing examining the degree of deference, another issue we can talk about at length at some point, on the federal courts in their granting of deference to regulatory agencies and examining that agency deference and what happens in the days ahead and the trends that we're facing on that. This concludes our hearing today. I'd like to thank our witnesses very much for your testimony. Your written record obviously is a part of the full long-term record. The hearing record itself will remain open for 15 days till the close of business on March the 10th for the submission of additional statements or questions for the record. With that, this hearing is adjourned.